Hello, hello. Naririnig ba ako dun sa sounds na to? Sound check, sound check. Okay. Okay. Uh, Remrev Q&A tayo. Okay, game. Okay. Next question. So guys, hindi itong video na to is not sponsored by Pro, pero nanghingi tayo ng consent kay Attorney Gib, yung may-ari ng Pro na gamitin na sa live stream. So, if magustuhan nyo tong video na to and gusto nyo ng access dito, I would suggest you get a subscription of Pro until the bar exams. Pero, if gusto nyo mag-aral na lang with me, then gawin natin to together. Okay. So, ito yung ginagamit ko ngayon is Anki. So, I will use this only personally, no? I would not be sharing it to anyone kung may magtanong. But I encourage you to, explore ways paano kayo mas maging efficient sa pag-aaral nyo. So, the good thing about this is we have a question and answer type na dito sa Pro. So, now, I'll be using it to kind of do space repetition using Anki. So, Anki yung ginagamit kasi sa medical school, usually, ginagamit nila to actually recall all the details, the terms, the descriptions na kailangan nilang aralin for their exams, for their practice. And continuously nila ini-improve lagi dito. Parang ito na yung second brain nila. I learned that from, sino nga to? Yeah, I learned it from one of the YouTubers. So, ayun. So, yung forest. Okay. Sige. So, try natin. Remedial law. Okay. Sige. So, sa Pro, add tayo. Ayan. So, okay. So, question. Okay, sige. Expand natin ng konti ito. Wag na pala. Okay, yan. Saan na si Zainab? Oh, question. Saan na si Zainab at Brenda? Okay, zoom pa. Sige pa. Okay. Sige pa. Sige pa. Last. %150. Oh, okay na yung kanina. Di ba mga 130 lang? Sige, okay na yan. So, si Zainab, Glenda, and Rosmar had several business dealings. Okay? Natin siya dito. Zainab purchased from Glenda 1 million pesos worth of beauty products. On the other hand, Rosmar borrowed from Glenda 2 million pesos as additional capital. Ay, ito lang. Okay. Sige. On the other hand, Rosmar borrowed from Glenda 2 million pesos as additional capital. Zainab and Rosmar promised to pay their respective obligations to Glenda after 1 year. On due date, Zainab paid Glenda only 700,000 pesos. So while Rosmar did not pay any amount despite repeated demands, okay, aggrieved, Glenda filed a complaint to recover 2,300,000 pesos against Zainab and Rosmar before the regional trial court. Okay, so ano ba yung question? Does the RTC have jurisdiction over the complaint? Sige, try natin sagutan. Ang jurisdiction ng RTC is more than 2 million pesos kapag money claims. If natama yung naalala ko. So, ibig sabihin nun, if that is the case, then, pero pag titignan mo siya, parang nagkaroon ng joinder of causes of action. Parang, ang naniningil, si Glenda, pero si Zainab at si Rosmar yung sinisingil. Eh sabi naman dito, they had several business dealings. So, ibig sabihin nun, it's not one transaction that gives rise to the obligation for the money claim. So, in short, walang isang cause of action dito. Okay? The subject is claims, money claims, pero magkakaibang transaction. So, ibig sabihin, considering na si Zainab, nagbayad siya ng 700,000, eh, 300,000 lang yung natira kay na dapat bayaran ni Zainab. So, 300,000 out of the 2.3. Tapos si Rosmar na nangutang ng 2 million as additional capital, wala siyang binayaran, 2 million. Hindi naman siya nag-exceed ng 2 million. So, ibig sabihin, walang jurisdiction ng RTC kasi isang 2 million at isang 300,000. Siguro kung isang transaction to at nag 2.3M yan, and parehas siyang isa sa kanila is nasa jurisdiction ng RTC, pwede sigurong magsama to. Magkaroon ng jurisdiction yung RTC. Pero dahil parehas walang jurisdiction ng RTC kasi isang 2 million, isang 300,000. So walang jurisdiction ang RTC. In that case, the answer na huhulaan natin is no, the RTC doesn't have jurisdiction over the case. Okay? Tapos, ang natin dyan, under the rules, the jurisdiction of the Regional Trial Court, RTC, is for over money claims is includes no is the jurisdiction of the RTC over money claims is for those not exceeding 2 million pesos. For those exceeding pala, sorry. Stopwatch tayo. Okay. Here, the money claims amount to only 300,000 pesos and 2 million pesos respectively. There can be no joinder of causes of action in this case, as causes of action arise from separate transactions. Hence, RTC would not have jurisdiction over this case. Hehe. Anong sagot? No, the RTC has no jurisdiction over the complaint. Under the rules on civil procedure, a party may in one pleading assert, in the alternative or otherwise, as many causes of action as he may have against an opposing party. Under the amended law on jurisdiction, first-level courts have exclusive original jurisdiction against money claims not exceeding 2 million pesos. Sobrang raw naman ang sagot ko. Here, Glenda misjoined her causes of action against Zainab and Rosmar. The liabilities of Zainab and Rosmar against Glenda arose from different transactions and should not be joined. Okay. Zainab has a liability of 300,000 while Rosmar has a liability of 2 million. Each cause of action is cognizable by the first level courts and not the RTC. Ano ba? Siguro 3 to 4 points ko. Bibigyan ko. Sige, kunin natin yung suggested answer. So, lagyan natin siya dyan. So, yan, suggested. Okay. Pwede ba magdagdag ng field? Fields. Add. 3. Suggested answer. Pwede ba yun? Full upload of the database. Okay. Tapos, okay, save. Ano tsura nito kapag sinagutan ko? O kunyari, ayun na. In-explore natin yung Anki, guys. So, ito na yung isa kong card. Browse natin. Kunyari, re-reviewin ko siya. No? Study na. Oh, tapos, no. The RTC doesn't have jurisdiction over the case. Ede, sagot ko to eh. Pwede ba ako magdagdag ng ano dito? Edit. So, suggested answer, lagay natin dito. Tapos itong sagot ko, lagay natin dito. Yan. Okay. Tapos, ano yung tsura ng card? Okay, front template. Sa front, gusto kong isama yung field, add field. Add natin yung suggested, yung ano pala. Pwede ba magdagdag ng fields? Pwede ba mag-add? My answer. Okay, ano nangyari dun? Okay. Ito yung tsura nun. Field. Ano ba mga card type ko? Suggested answer. So, ano itsura niya? Review. Di bang gumawa? Wala mag-view card. Add. Type in the answer. Yun. Tapos fields. Saka natin figure out to. Di-distract lang ako. Let's go po. Add. Okay, next. 7 minutes. Okay. Ulrich is resident and owner of a house and lot situated in Pasay City. Thereafter, Ulrich discovered a deed of real estate mortgage over the house and lot which he supposedly executed to secure a loan from Nigel. The mortgage contract contained a stipulation that all civil actions arising from or connected with this instrument or any of its provisions shall be brought before the proper courts of Bacolod CD, to the exclusion of all other venues of action which are hereby expressly waived. Aggrieved, Ulrich filed against Nigel an action to declare void the spurious deed of real estate mortgage before the regional DND. I-distract ako. Okay. In his answer, Nigel raised an affirmative defense that the venue was improperly laid. The action must be filed exclusively in Bacolod City pursuant to the mandatory venue stipulation. Okay. So, ang naalala ko sa case na ganito, when there is a mandatory venue stipulation, the same will be followed regardless of whether it is a personal action or a real action. However, if the issue at the case is the validity of the contract itself, of the mortgage contract itself, then you would not follow the venue stipulation, because if the contract is deemed, for purposes of discussion, it's void because it's being questioned, and then this means that you have to follow the general rule. You disregard the mandatory provision, check whether this is a real or personal action. So, in this case, ano ba yung sabi ni Justice Henner is, kailangan mong alamin ano ba yung allegations in the complaint and the prayer asked. Ang prayer dito is, to declare void the spurious deed of real estate mortgage. Okay, so declaring a contract void is what? Is it a real, question is real action ba to? So, tingnan mo, tip, sabi ni Justice. Meron kang interest, possession, at title. Pag na-declare na void yung deed of real estate mortgage, ano ba yan? Void yung real estate mortgage. Does title change? No. When you do mortgage, the title still rests with the owner. Tip, interest. No. In a mortgage, it's just to secure the transaction. Okay. And P, possession. Is there a change in possession when you do mortgage? None. So if that's the case, the residual definition would be personal action. If this is a personal action, then we follow either the place or the residence of the plaintiff or the residence of the defendant at the option of the plaintiff. Okay, so if that's the case, so sinong plaintiff? Ulrich. Okay. A resident and owner of a house. So wala namang problema. Resident siya, tapos yung house nandun din sa Pasay City. So walang problema, sa Pasay talaga siya. 'Di ba? Pinakompletado ko lang yung sarili ko. Yung Pasay, whether real or personal, Pasay. Pag masusunod yung stipulation, Bacolod. Sana tapos na ako kanina pa, no? Discuss pa ako sa sarili ko. Yeah. Sige, natuto tayo sa question na to. Okay? So, ano tsura nito? Kung may suggested answer. Sige nga. Pwede ba yung type in the answer tayo? Yan. So, sa back. Okay. Kunyari, lalagay ko yung answer, no? Ang answer ko is Pasay City should be the proper venue. This case. Under the rules on civil procedure. And there is a decision by the Supreme Court as decided by the Supreme Court when the issue at hand is pertaining to the validity of a mortgage contract, the mandatory venue stipulation shall be disregarded, shall not be controlling upon the part. Yeah, super legalese. Okay. Tapos, ano gagawin ko next? Gagawin ko next. Teka lang. Okay. So, when the issue attached pertain to the validity of under shall not be controlling upon the parties. Kaya ang init. Okay. Here, the Ulrich is assailing is Ulrich action filed an action for the declaration of nullity of the deed of real estate mortgage. Hence, the mandatory venue stipulation being ineffective, It does not matter. Okay, dagdagan natin. What will prevail is whether the action is of a personal or real is a personal or real action. Yeah, mortgage. It is of no moment that we determine whether this is personal or real as venue will still be in Pasay. Either way, for residents of is Ulrich and the location of the property are the same. Hence, the mandatory stipulation held ineffective. Pasay City should be the venue for this case. Okay. That was 10 minutes. Okay, sige. Mas bilisan pa natin. Okay. Pero, paano ako magdadagdag? Pwede ako mag-add ng field. Add. Suggested answer. Okay, save. Tapos, yung suggested answer is... Nasaan, boy? Ba't na wala? Hindi na siya nag-scroll. Kaya mag-scroll. Question, ano ba yun? Question 4? Hindi pala. Remedial. Question 5, 3, 4. Okay. Suggested answer. Okay. Yan. Nature nun kapag lumabas na. Okay. Browse. Review. Hindi. Nasaan yan? Ito. Review. Okay. Paano sagutan to? Paano ko aralin? Kunyari aralin ko lang. Ito na. Testing my answer here. Again. Test. Okay, ganun pala yung tsura ng card na ganun. Sheesh. Pwede bang palitan ko yung type nito? Okay. Pero okay na rin siguro yun. At least makaka-type ako ng sagot. Yung bumangga lang na characters, yun lang yung tinitignan mo. So maganda to for ano, mga definition or exact answer. Hmm, is there a way for me to like how to record answers in API? Hindi ko makita anong itsura nung sagot ko before. Paano siya nag-evolve? Wala ata akong choice. Baka dapat sheets na lang gamitin ko. Mag-sheets na lang ako. Oo, sheets na lang tayo. Sheets. Sheets or Excel or... Tara. Sheets tayo, boy. Sheets. Blank spreadsheet. Bar view. Okay, gawa tayo ng database dito. Question. Tapos, dito yung suggested answer. Tapos, ito yung my answer. Okay. So, copy-paste natin itong question dito. Okay. Pangit ng interface. Paano kaya mare-record yung sagot ko dyan? Screenshot ko na lang, no? Di ba maglagay ng notes? Ano ba yung reverse card? Ano itsura ng reverse card? Reverse card. Bumabaliktad lang siya. Paano mag-delete? Paano ko delete? Paano mag-delete? How do I delete this card? Paano? Auto delete cards. Browse window, control delete, command delete. So then delete. Notes. Pwede ko dito delete. Kaya pa din. Ito. Hindi tayo mag-delete. Sige, delete ako. Yung. Okay, good. Sige, game. Alam ko na. Para ma-record ko yung sagot ko. Dito na lang. Nasaan yung sagot ko kanina? Ito. Ito yung sagot ko. Okay. Kailangan mo gumaling, Carl. Bigyan natin ng points yung sarili ko. Pwede ko 4. Generous na ako niyan. Sige, pwede na yan. Okay, game. Next. Add. Sabi. Gomez died, leaving his wife Morticia and daughter Wednesday. Okay. So, dito basic lang. Okay, is the RTC correct? For probate, for failure to allege earnest efforts toward the compromise. Hindi ko pa alam to. Anong sagot? No, the RTC erred in dismissing the petition for probate. The court has held that the rule set out in Article 115 of the Family Code shall not apply to cases which may not be the subject of compromise. Under Civil Code, jurisprudence teaches that special proceedings cases for the probate of a will is not subject to compromise. Okay. Here, the probate petition cannot be subject to a compromise. Thus, Article 151 of the Family Code is inapplicable. Okay, so Article 151 is compromise agreements. Hindi siya applicable dito. Okay, sige. Next tayo, next. Ito, ba't ganito? Refresh. Question 6 na tayo. Question 6. Rem. Okay. Ba dapat ko mag-zoom out ng konti? Zoom in. Yan. Zoom out natin ng konti. Yan. Okay. The Department of Public Works and Highways. National infrastructure project that will connect the major highways in the country. Tanong muna, writ of possession, validly issued. Okay. Traverse Street property situated in the Bacoor Committee will be affected by the implementation of the project. The DPWH, through the Office of the Solicitor General, then initiated expropriation proceedings with motion for the urgent issuance of writ of possession. DPWH attached a manager's check equivalent to 100% of the zonal valuation of Traverse property, indicated the Office of Clerk of Court, Regional Trial Court of Bacoor Cavite as payee. The DPWH furnished Trevor with copies of the complaint, motion, and manager's check. The motion was set for hearing. Thereafter, the RTC issued the writ of possession. Trevor questioned the propriety of the issuance of the writ of possession because he was not afforded due process in determining the valuation of his property. Ang tanong is, ang issue talaga dito is may due process daw ba? Kasi the validity of the issuance of the writ of possession supposedly rests, as argued by the plaintiff, with the due process. Okay. Okay. Was he afforded due process? So, meron namang copies ng complaint, motion, and manager's check si Trevor. Hindi siya na-set for hearing. Ang due process naman kasi sa mga expropriation is mostly as to the determination of a two-step process. Two-prong approach na ulit sabi. Una is there the authority to expropriate, and then just compensation. Okay. Is there authority to expropriate? DPWH, yes. So, just compensation na lang. Even without a hearing. Hindi ko naman sabi. Pero sa hula ko, although hindi siya validly issued, although hindi nga siya na-afford ng due process, hindi pala. Hindi valid yung issuance ng writ, pero okay lang na proceed with the writ. Because ang susunod naman is determination of just compensation. Pero, hindi ko alam ang sagot kung paano siya i-phrase. Tingnan natin. Okay. Valid daw pala. So, in case of a prosperation, the government shall deposit with the court an amount equal to 100% the current zonal valuation. After deposit, the court shall immediately issue. Okay. So, kailangan lang mag-deposit. Tapos pwede nang mag-issue ng writ of possession. Pwede yung implement. There was no need for a hearing to determine just compensation prior to the issuance of the writ of possession. The owner of the property expropriated contests the amount. He may file a motion with the court. The court shall determine the just compensation to be paid the owner within 60 days from the date of filing of the expropriation case. Okay. Sige. Gets. Okay. Next. Sige, basahin na lang muna natin yung mga sagot. Familiarize natin hulaan natin yung sagot, guys, bago tayo mag-practice. Myrna leased her real property to Gabin for a period of 1 year. However, Gabin refused to vacate the premises after the expiration of the lease. Myrna then filed against Gabin an unlawful detainer case. Okay. The METC ruled in favor of Myrna and ordered Gabin to surrender the real property, penalizing si Gabin. Judgment of the METC lapsed into finality but was not enforced. For humanitarian reasons, si Myrna, ang galing, pinalayas na ng court si Gabin. Pinabayaan pa ni Myrna magstay ulit si Gavin dun sa real property na yun. Tapos, ayun, nag-demand naman. Tapos, ang sabi lang, babalik ni Gavin yung property pag kailangan na. Tapos, nung dinamanda ni Myrna na, alis ka na, Gavin. Hindi siya umalis. Myrna filed against Gavin another unlawful detainer case. Okay, in his answer, sabi ni Gavin, yung second ejectment case ko, barred na yun by final judgment. So, res judicata na to. Okay, so does the res judicata bar the institution of the second unlawful detainer case? Answer ko, no. Try natin na no. Res judicata is not proper in this case. Under the law, res judicata only attaches when there is an identity of the cause of action and the parties to the case. Here, there is no identity of cause of action as the cause of action of the second case rests on the is on the refusal of Gavin to vacate for the second time. Hence, there would be no res judicata in this case. Okay. So, anong tamang sagot? Jurisprudence that one of the requisites for is identity of cause of action. The cause of action, tamo, one of the requisites nga lang eh. Diniscuss ko pa yung identity ng parties. Hindi naman kailangan. Ay, nako, Carl. The cause of action of the first unlawful detainer case was due to the expiration of the lease contract. On the other hand, the second case was based on Gavin's refusal to vacate. Okay. Ang haba ng sagot niya, parang same concept naman. Medyo mas maigli lang sumagot. Siguro 4 points naman to, no? Medyo. Anyways. Pero doon pa rin tayo sa suggested answer. Medyo mas professional siyang tingnan kaysa doon sa sagot ko. Jurisprudence dictates. On the other hand. Okay. Next. Remedial Law 8. Amor filed against Yoda in the Register of Deeds an action for reconveyance, nullity of sale, cancellation of certificate of title before the RTC. Amor alleged that Yoda unlawfully obtained a certificate of title when he registered the disputed land in his name based on a falsified deed of sale. Kaya nga, Tagalogin natin. Tandaan. So, si Amor nag-file kay Yoda an action for reconveyance, nullity of sale, and cancellation of certificate of title. Okay. So, yun yung kaso ni Amor versus Yoda. Amor, sabi ni Amor, ah, illegal daw na nakuha ni Yoda yung titulo niya. Kasi, yung deed of sale na yun, peke naman yung deed of sale ni Yoda. Tapos, nung tinry out ni RTC, nalaman niyang si Amor ang owner and yung void yung sale. However, sabi ng RTC, okay, nakalimutan ng RTC na i-order, i-cancel yung titulo ni Yoda. Okay, the decision became final and executory. Okay, so naglapse na yung period of appeal, 15 days. Okay, Amor move for clarificatory inquiry about the emission in the dispositive portion. Pinaklarify lang ni Amor, parang na-miss out mo to, Judge. RTC clarified its final judgment. It required the RD to cancel the certificate of title. Okay. Sabi ni Judge, ay sorry, oo nga, sige, pa-cancel nga ng certificate of title. Sabi ni Manioda, Judge, yung pinagagawa mo, hindi mo na pwedeng paltan yung judgment mo dati, nag-final judgment na yon, diba? Hindi mo na pwedeng i-update yung ruling mo. Nakalimutan mo nang isama yung cancellation ng title, hindi mo na pwedeng idagdag na yun. Final na yun eh. Ngayon, ang question, did the RTC violate the doctrine of immutability of judgment? Oh. So, pwede pa bang kang bawi kay judge? Yun ang question ngayon sa case na to. Okay, back. Suggested answer. Sige, manghula muna ako. Hindi pala dapat suggested answer yung ano ko. Dapat pala ang pangalan is my answer. In him. My answer. Okay? So, ibig sabihin ito yung first answer ko. The first time na nilagay ko siya sa dito. Okay? Sige. So, ang tanong ko dito, sagot ko dito, no, there is no violation of the doctrine of immutability of judgment. Under the rules, okay. Administrative errors. Nanguhula na lang ako ngayon. Maybe corrected without resulting to a violation of the doctrine of immutability of judgment. Here, the correction by the RTC does not change the substance of the ruling. It merely added such necessary details to promote the ends of justice. And okay na yan. Nang bola-bola na lang tayo. There is no violation of doctrine of immutability of judgment. Okay, anong sagot? Sagot. Okay, sabi, the court has held that the court may clarify and a final and executory judgment. A judgment is not confined to what appears on its face, but extends as well to those necessary to carry out the decision into effect. Here, the RTC declared void the sale of the registered land. It, however, failed to order to fully carry out the decision, may correct its judgment, include the cancellation of the title as it is a logical consequence of its order. Oh, di ba? Yung bola-bola system natin, baka maka 3 points pa yan. Tama naman yung no. Medyo malapit naman yung justification. Simple lang, pero sige. Justify yung sagot. Kunyari 3 points yan. Sana sa bar, ganun talaga yung sagot na. Sige. Sige, here. Okay, das. Alright. Spouses Poblete versus Bangko, Philippine Savings. Okay. Lap, 9 minutes. Sige, next tayo. Next. Ombudsman, teka, question. Sino may sa jurisdiction? Sandigan Bayan or the RTC? Okay. So, question. Ombudsman filed information against Mayor Isidro for violation of the Anti-Graft and Corrupt Practices Act sa Sandigan Bayan. Sabi sa information, si Mayor with salary grade 30, while in the performance of his official and administrative functions, acting with evident bad faith and manifest partiality, did then and there willfully, unlawfully, and criminally give unwarranted benefits to ABC Corporation by allowing it to operate the dump site without the necessary environmental permits and clearances, causing undue injury to the residents, caused to ensure the stench, flies, rats, and mosquitoes emanating from the dump site. So basically, sinasabi dito, sabi ng ombudsman, kurap si Mayor Isidro kasi pinabayaan niyang mag-operate yung dump site kahit walang permit. Okay? Sabi ni Mayor Isidro, mali yan. Wala kayong jurisdiction sa akin. Kasi RTC at hindi Sandigan Bayan ang may authority to decide the controversy. Okay, rule. Sino merong jurisdiction? Sandigan Bayan o RTC? Ang specific na jurisdiction afforded, ano ba to? Sa 3019. Ano ba to? Ang hirap naman sagutin. Manghula ko hula tayo. RTC Sandigan Bayan. Hindi pala. 3019 nga pala, no? Hindi ba specific sabi ng 3019? RTC to. Ang hirap. Sige. Ako na lang ito try sagutin. Sayang time. Ba't na wala? Ba't hindi ko makita yung sagot? Ba't napuputol? Minus, plus. Yun. Sabi, okay. O RTC. Ang galing ko manghula, di ba? RTC. Pala, nanghula na lang ako. May points yun. Pero RTC has jurisdiction over the criminal case. Section 4 of PD 1606 provides that the RTC have excluded where the information does not allege any damage to the government or alleges damage to the government not exceeding 1 million pesos. Here, the information does not allege any damage to the government or that there was bribery. What alleges that given warranted benefits by allowing it to operate. Okay. So, tatandaan mo, Carl, kapag pinag-usapan is PD 1606. Ano yung PD 1606 nga ulit? PD 1606. 1606 talks about, ano to? Okay. Yung Sandigan Bayan mismo. The creation of the Sandigan Bayan by President Marcos. Galing din talaga, no? Gumawa siya ng separate court para mag-try sa mga corrupt na officials. O, diba? Okay, sige. Basta kapag 1606, pag Sandigan Bayan, ang kailangan is may damage to the government. Or kung may damage, okay. Kapag walang allegation ng damage, or may allegation man pero less than 1 million, not exceeding 1 million, RTC yan. Okay. So, ang kukunin lang ng Sandigan Bayan is yung sinabi, yung may damages more than 1 million. In short. So kung less than 1 million ang damage, RTC. Tandaan mo yun, Carl. Okay, yun lang. Yun lang tatandaan natin sa case na to. Okay, next. Lap. 5 minutes. Okay, the PIDEA. Okay, issuance of a valid warrant. Nakuha sila ng tip na sabi nitong si Asset, si Aidan, may bentahan daw sa QC. So, punta ngayon ng PIDEA. Tapos, nag-file yung mga agents ng PIDEA ng search warrant sa Manila. Sabi nung uh, sabi ng PIDEA agents, meron daw si Aidan na 2 kilos of shabu in his residence ready for disposal. Si Aidan pala yung pusher, sorry. Meron tayong tip from an informant na si Aidan pala ay sa pusher. Tapos, sabi ng PIDEA agents, magagamit sila ng body-worn cameras. The executive judge of the RTC of Manila granted the application, issued a search warrant. Okay. Seized 2 kilos of shabu from Aidan. Is the issuance of search warrant valid? Valid ba yun? Manghuhula ako dito, no? No. It is not valid. Maikli ang sagot lang. The requirement tip is not a valid ground to issue a valid search warrant. Parang ganyan. Sige, kunyari yan lang. O sige, yung sagot ko. Pero hindi ko sure. Okay. The rules on the issue of body-worn cameras is the execution of warrants. So kailangan daw ng endorsement ng head ng PIDEA. So sa endorsement pala nagkaroon ng defect. Okay. Well, at least tama yung no natin. Siguro may 2 to 3 points na tayo doon for the no. Or kahit 1 point man lang po. Judge, examiner. Okay. Next. Put me 3 minutes. Okay, 2:57. The METC convicted. Teka, question. Appeal. Dismissal of appeal for a failure to file the required memorandum. Okay, question is memorandum. Sabi lang naman, METC convicted Ivanka of theft and imposed upon her the indeterminate penalty of 1 year, 8 months as minimum to 3 years, 6 months, and 21 days as maximum. Ivanka timely filed a notice of appeal. The METC then transmitted the records of the criminal case to the regional trial court. Thereafter, the RTC directed Ivanka to file a memorandum of appeal. However, Ivanka failed to submit her memorandum despite notice. The RTC then dismissed Ivanka's appeal for failure to file the required memorandum. So, question dito is, issue talaga is, kailangan ba talaga yung memorandum when you're doing the appeal? Okay? Ano ba to? 1 year and 8 months to 3 years, 6 months. So, hindi naman to reclusion perpetua whatsoever. Sige, hula ko. Required. Yes. Properly dismissed. Ano to? Memo is required. to appeal. Check natin kung tama yung concept ng sagot ko. Okay, mali. Okay, sabi dito, within 15 days from the receipt of said notice, the parties may submit memoranda. After submission of such memoranda, or upon the expiration, shall decide the case on the basis of the entire record of the case, and of such memoranda or briefs as may have been filed. Okay. Hindi naman required mag-file ng memo. Pag nakapag-file ng memo, edi hindi siya mako-consider. Pero kailangan mag-render ng decision ng RTC or ng court. Hindi pwedeng i-dismiss lang. Mag-decide siya kung ano meron sa kanya. Okay, yun ang sagot. Okay, sige. Iwalay natin yung ating alak. Answer, legal basis, sa ng ating application. Okay. And then, conclusion. Thus, okay. Next. Next. Okay, question 12. Oops. Testimony of the social worker, hearsay. Okay. Hearsay. Evidence to. Evidence. Fermi and his 11-year-old son Carter, residing in the province. Vincent, a talent manager, recruited Carter to be a child actor. Fermi agreed and gave parental consent. Vincent brought Carter in Manila. Okay, dinala si Carter sa Manila. Nilak siya sa small room, tapos pinili siya makipag-sex with clients. After 1 month, Vincent brought Carter inside an operating room. Tinanggalan siya ng, ano ba ito, mata? Corneas. And binalatan siya. Grabe naman. Tapos, ni-raid yun, na-rescue si Carter, na-arresto si Vincent. Yung social worker na nag-interview kay Carter, ninarate niya kung paano ano yung mga sinabi sa kanya ng bata. Tapos, na-diagnose si Carter ng PTSD. Okay? The prosecution charged Vincent with qualified human trafficking. Kaso, however, Carter refused to testify. Hindi daw makatestify ngayon si Carter, yung bata. Kasi nga, trauma pa eh. Tapos, ang tinawag ng prosecution, ang witness, is yung social worker. Yung psychologist. Okay? Para ma-establish yung charge. Okay. Vincent objected about that. Yung, ano daw, is hearsay daw. Okay. Para tong yung tanong kanina. Sagot dyan. No. Sagot ko is no. The testimony of the social worker. Yes pala. Hearsay siya, pero it's one of the exceptions. Hearsay siya, pero admissible siya kasi one of the exceptions. So, anong sagot ko? Yes or no? Yes. Testimony of the social worker is hearsay. However, it is admissible as an exception. Under the rules, one of the exceptions for hearsay evidence to be admissible is when it pertains to, when it is an independent, irrelevant testimony. Where the declarant is not testifying for or on behalf of another person, but rather is testifying on his or her personal knowledge. Okay. Here, the social worker will be testifying testimony can be counted as an independently relevant testimony. Hence, even though it is hearsay, it is still admissible. Ang haba ng sagot ko, tas mali pa rin, no? O, di ba explain niya rin yung admissibility? Pero hindi ko nabanggit yung rule on examination of child witness. The rule on examination of child witness expressly allows. Okay. Mali yung basis ko. It is corroborated by other admissible evidence and the child is unavailable. Yung PTSD niya, okay. Okay. Here, Carter is considered unavailable to testify kasi may PTSD siya. O kailangan i-corroborate with other admissible evidence. Shemay. Pwede kaya, lumusot kaya yung sagot na yan kapag examiner? Hindi ko masabi. Siguro, possibly. Depende kung ano ba, tumbok pa. Hindi ko nga alam kung possible bang ang basis ko is yung independently admissible something na yan. Bola-bola system. Sige, babalikan kita. I shall get back to you. Okay. 500. Konti na lang. 13 to 24 na yung sagutan ko. 500. Konti na lang. Remedial pa lang yun. Upo. Buti ka pa, Esnir. Nandito ko sa tanong. Sumasayo yung buhay. Okay. Esnir filed against Fonzie. O, pati si Fonzie. A complaint for sum of money with prayer for preliminary attachment. Esnir alleged that Fonzie failed to pay the consideration arising from their contract of service. Okay. Okay. Basically, may utang si Fonzie kay Esnir. Tapos, niremata na yung namarkahan na yung property ni Fonzie nung namatay siya. Bago siya mamatay, namarkahan yung property niya na pambayad sa utang kay Esnir. Okay? Na levy na. Tapos namatay si Fonzie. Okay? Ngayon, nung namatay si Fonzie, sabi ng mga kamag-anak, wala na. Tanggalin nyo na yung levy dito sa property na to. Gusto na namin itong pakinabangan. Levy means hindi nila pwede ibenta, whatsoever. Naka-allocate na siya kay Esnir. Ngayon, sabi ng mga kamag-anak sa court, pwede bang pakitanggal na lang nung marka ninyo? Kasi hindi namin ma-enjoy yung use itong estate na to. Hindi namin ma-dispose yung estate ni Fonzie. Sabi ng court, your wish is my command. Okay. Question. Tama ba yung trial court na tinanggal niya yung levy do sa property? Dinissolve niya yung rate of preliminary attachment? My answer, no. The court is not. Ano sabi? Is not correct in dismissing the rate. Okay. Anong magiging basis ko? Under the... Pwede bang as decided by Supreme Court? Kahit wala akong alam na jurisprudence. Kung hindi mo alam kung anong batas mo. As decided by Supreme Court. The levy of property will not be lifted upon the death of its owner. Tapos lagyan natin ng palabok. The levied property is already allocated to the judgment in award to a favorable judgment to an adverse to a creditor. In order to exact the collection of sum of money due to him. Ayan. Okay na yan. Napalabok na. Okay, next. Here, the property of Ponzi has been properly levied, has already been levied before he died. Hence, the levy cannot be easily lifted, and the court erred in dissolving the writ of attachment. Okay, hulaan natin. No. Whenever a party to a pending action dies and the claim is not thereby extinguished, it shall be the duty of his counsel to inform the court. Okay? Okay. The heirs of deceased may be allowed to disabuse. When the action is for recovery of money arising from a contract and the defendant dies before entry of final judgment, in which the action was pending at the time of such death, it shall not be dismissed, but shall instead be allowed to continue until entry of judgment. Now here, the action of sum of money shall not be dismissed despite the death of Ponzi. Thus, it was improper for the court to dismiss the complaint. Di ko alam kung yung basis ko. Ano ba? May point ba dito? Well, tumama naman yung no. Siguro mabigyan ng 3 points. Tapos kung hindi na binasa, edi swerte. 5 points. 4 points. Diyos ko po. So, ang sabi dito, for action recovery of money arising from contract, express or implied, the defendant dies before entry of final judgment in the court was pending at time of such death, it shall not be dismissed. Okay, so ibig sabihin, ang dapat kong tandaan sa case na to, kapag may utang, hindi nabayaran, dissolve yung utang. No? Sum of money. Pero kapag may utang, na i-file sa court, may trial na, namatay during trial, tuloy ang trial hanggang final judgment, hanggang ma-execute at makasingil si plaintiff. Okay, gets. Nagugutom ako. Nagugutom. Okay, here. Gutom ako. See? Sige. Next. 7 minutes. Pwede na. Yung 7 minutes yung target natin sa bar. Yan yung sinabi ng legal edge. Kailangan. Okay. Okay, ang tanong. Are text messages inadmissible in evidence? Admissible yan na. Tignan natin. Pinadisbar ni Virgil si Atty. Flores dahil daw scammer siya. Virgil allege, nagbayad daw siya ng malaking pera kay Atty. Flores. Nasabi, mananalo tayo, madam. Tapos, inaresto ngayon si Atty. Flores kasi nagbebenta ka ng peking panalo. ang sigurado kong panalo ka, supporting evidence. Sinabit ngayon ni Virgil yung screenshots ng usapan nila ni Attorney Flores. Tapos ang sabi doon, if you send 400,000, you will surely win the case. Sabi niya, attorney, I already deposited the amount. Thank you. Okay, received. Let's wait for a month according to the judge. Pero, si Attorney Flores, sabi niya, wala naman kayong proof na yung mga text messages na yan, galing yan sa akin. Nakaregister yan sa akin. So thus, the text messages are inadmissible in evidence. Okay. Text messages. No, they are admissible. Under the rules. Text messages. Pwede bang as ruled by the Supreme Court na lang? Yun na lang yung entry ko. As ruled by the Supreme Court. Hindi ko alam kung anong case. Hindi ko nga alam kung may case talaga. Nanguhula lang ako ngayon, guys. No, they are admissible as ruled by the Supreme Court. Text messages are admissible in evidence insofar as they are they can be classified as original document evidence. Because screenshot means to replicate them by use of media, modern technologies. Yeah, here text messages were reproduced in court through the submission of the screenshots of such text messages. They may be treated then as original evidence submitted to the court. Hence, text messages. Parang walang sense yung logic ko. Should submitted as screenshot shall be admissible. Shall be admissible. Okay. Anong sagot? Yes. Rules on electronic evidence pala ang basis. Writing, document, record. Electronic document. Okay. Anong sagot? Copy-paste na lang natin dito. Lagyan natin dito. Okay, yes. An electronic document should be recorded as equivalent of an original document. Oh, di ba? Original document. Original document rule. If it's a printout or output readable by sight. Oh, screenshot. Medyo may point naman tayo Considered electronic evidence. Hindi ko lang nabanggit yung electronic evidence. Pero tama naman yung yes. Ano naman, mabigyan ng 5 points. So yung issue naman na may proof ba kayo na ako yan? It goes beyond admissibility. So hindi na natin kailangang i-resolve yun kasi ang tanong lang naman is admissible ba ang text messages? O, di ba? Yan ang natutunan natin sa case na to. Sa question na to particularly, hindi natin kailangang i-rule lahat. We don't rule on the probative value and weight of the evidence, but rather we just rule on the admissibility. Yun lang ang tanong Let's go. Okay, next. Camilson. 546. Yeah. O, si Rigor. Rigor. Marites and Lena are best friends. Eventually, Rigor married Marites, but they separated due to irreconcilable differences. Okay? Best friends daw si Rigor, si Marites, at si Lena. Tapos, si Rigor, pinakasalan si Marites. Pero naghiwalay sila. Kasi irreconcilable differences eh. Mga hindi pa pagkaunawaan. After 5 years, binisita ni Marites si Rigor sa apartment nila. Baka magkabate. Tapos nagulat siya, nagulat si Marites, nandun pala si Lena. At magkasama sila live-in ni Rigor. Aba, nagselos ngayon si Marites. Ngayon, nasa bunutan niya si Lena. Yun, nagkaroon ng contusions and trauma. Sabi ng public prosecutor, okay, serious physical injuries, Marites. Sa trial, tinawag ngayon si Gore in the witness stand to testify on the incident. Sabi ni Marites, aba, teka, mag-asawa pa kami niyan si Rigor, hindi pa kami naanal niyan, no? So, ibig sabihin niyan, hindi siya pwedeng mag-testify sa akin. Marites argued that her marriage with Rigor, okay. So, ibig sabihin nun, yan, yung prohibition na yan talaga is meant by the law na parang hindi masira yung marital relationship. Hindi pwedeng, alam mo yun, unless kayo ang nagkakasuhan sa isa't isa, kung iba nagkakaso sa inyo, hindi pwedeng mag-testify yung asawa nyo against you. Okay? That is the general rule. That is what we call the marital disqualification rule. Okay, may answer. Yes. Marital separated. Wala naman sinabing legally annulled. Okay? Yes. The marital disqualification rule is applicable. Under the law, under the rules on evidence, alam natin, Kalisa rule of evidence yan. The marital disqualification rule states that spouses cannot testify against each other. Kailangan ko ba bang i-mention yung exception? Sige, para humaba na konti. Except when the case is filed by one against the other, or the latter's for damages. For an offense. Huwag na ka mag-exception. Sige, against the other. Meron kasi diyang ascendant, descendant, hindi naman kailangan discuss. Okay, here, Marites and Rigor are still validly or legally married. Married despite their physical separation. Thus, the marital disqualification rule will still apply. Okay? Okay. So, bago ako mag-next, sagot na ang sagot. Okay. Without the consent of the affected spouse, except in civil case filed by one against the other, or criminal case for crime committed by one against the other, or the latter's direct ascendants or descendants. So, legally married pa rin sila. 5 points to Kahit maikli lang yung sagot ko, hindi naman ganun hindi makala-discuss yan. 5 points. Nag-assume. Nagugutom ako. Ano ba yun? Pero makakain dyan. Kaya nga, hindi makangata ako dyan. Okay? Lap 5 minutes and 27 seconds. Okay, next. Legal ethics. Tigtangan ko muna yan ha. Huwag muna yan. Tigtangan ko muna yan. Hindi ko pa natapos lahat yung legal ethics. Spectro. Sheesh. Ito hindi ko na-master. Kala mo na-master ko iba. Colleen is strict. Ang tanong. Will petition for habeas data prosper? Okay. Question lang naman to eh. Sabi, strict daw si Colleen na team leader. Galit sa kanya yung mga tao. Dahil galit sa kanya yung mga tao, ngayon, tinadestino siya sa malayo. Ngayon, ang sabi ni Colleen, oh, patigin ako ng ebidensya nyo. Ano nga, bakit ang basis nyo, bakit nyo ako tinatransfer? Ano to? Parang constructive dismissal to. Now, nag-file ngayon si Colleen ng petition for habeas data. Tanong, will the petition for habeas data prosper to protect Colleen's right to security of tenure? My answer, no. The petition will not protect her right to security of tenure. Under the law, it is management prerogative. There is delicate balance between the exercise of management prerogative and the right to security of tenure. Management, business owners are not precluded from making decisions that would further their goals as a company. From exercising their management prerogative and are not required to disclose to their employees the rationale of such decisions. Here, Colleen is requesting for the information, for the basis of this transfer. And that such refusal by management to disclose the same is tantamount to his violation of to a violation of his right to privacy and security of tenure. However, the right of security to tenure, right to privacy, and is not reliant on, will not be impacted. Hence, the petition will not protect the Collins right to security of tenure. Okay. Anong sagot? No. Sagot. The habeas data will not prosper. The availment of the right of habeas data requires the existence of a nexus between the right to privacy and the right to life, liberty, or security. Okay. This transfer to another state does not amount to a threat to right to life, liberty, or security. So, dapat ang basis ko, there must be a threat to right to life, liberty, or security. Okay. Yun dapat yung basis. So, at least tumama tayo sa no. Pag hindi binasa, pag nabait, mga 3 points. Tama naman yung no. Oh, lap. 7 minutes. Pwede na. Kaya pa natin bumalis. Siyempre, pag sa ulo ko na to, kaya ko nang sagutan to. Front. Okay, tanong. Rafael Beatriz filed an action for recovery. Ang tanong, are the counterclaims within the jurisdiction of the RTC of Taguig? Okay. Si Rafael nag-file ng action for recovery of sum of money, 2.5 million against Tess sa RTC. Okay. Attached to the complaint was a promissory note, check issued by Rafael to Tess, and a copy of the withdrawal slip from Banco de Ocho, Rockwell Branch, Makati City. In her answer, Tess raised as her compulsory counterclaim the recovery of her attorney's fees in the amount of 500,000 arising from the case, and a permissive counterclaim against Rafael Beatriz for rescission of contract of sale involving unnatural rules. Tess paid the filings of her permissive counterclaim. Are the counterclaims? Okay. No. No. The counterclaims are not within the jurisdiction of the RTC. Under the rules, under the law, under the rules, the jurisdiction of the RTC with respect to counterclaims is also under the rules, the RTC has jurisdiction over counterclaims arising from or are intimately arising from, related to the cause of action, to transaction pertained related to the cause of action. RTC has jurisdiction over counterclaims arising from or are intimately related to the cause of action. the case, regardless of amount, if the, however, ano to, permissive, compulsory. However, for compulsory, for permissive counterclaims, jurisdiction depends on the amount paid for, which must be more than 2 million pesos. Here, the compulsory counterclaim is within is pertaining to the recovery, attorney's fee, recovery of attorney's fees for this same case. The permissive count, however, is pertains to a separate transaction and is and the sum paid for does not is paid for does not convey. Ano ba convey? It does not grant. Pertains to separate and the sum paid for amounting to 2 million pesos is not within the jurisdiction of the RTC. Okay, hindi ko na sasabihin na pwede niyang i-file separately to upon dismissal. Okay, sige. Hence, the compulsory, mas pwede ng compulsory. Compulsory counterclaim is within the within jurisdiction of the RTC. Mali pala. Yes and no pala dapat to. Yes and no. Copy-paste na lang natin ito. No na lang. No. Yan. Okay, anong sagot? Paano ba yan? 5 points to. May pa section 7 siya. Wala akong alam sa section, sa totoo lang. Wala akong alam na codal. Na may section. Arises such may be with the jurisdiction both as to the amount and the nature thereof, except that in a regional action before the regional court, the counterclaim may be considered compulsory regardless of the amount. First is one that must be filed with the court having jurisdiction over the amount. But it's within. Oh, di ba? 5 points. 5 points, mga kababayan. 5 points. Salamat po. Thank you for watching. Ano ba ito? Simula tayo dito. Yan. Space natin dito. Ba't pala pinipaste ko na lang dito pag binabasa ko kaysa yun? Here. Okay. Good, good. Ang galing natin magsagot, guys. 8 minutes. Oh, ha? Pwede, pwede. Pwede, 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 pwede. Nagtrinka borrowed 1.5 million from Ida. Okay. Sige. Next. Back. Ano sa back? Bakahin mo na ako. Basahin natin silently habang ngumunguya ako. Yung tanong dito, the dismissal of the case is due to the condition precedent, which is barangay conciliation. Yung TC. Hindi ko alam. Pero manghula ako dito. Yes. Barangay conciliation must be complied with prior to filing. Feeling ko no to, pero no. Sabi ko na nga ba? Okay. So, ang matututunan natin sa case na to, yes, required yung barangay conciliation as a condition precedent. So, prior to filing in court, dapat nagbaranggayan muna. Pero, it doesn't deprive the court of jurisdiction. Pero, additionally, kung na-raise siya as an affirmative defense, the failure to comply with the condition precedent, then, at that point, the court shall dismiss the case. So, ang nangyari kasi dito, motu proprio, meaning on the occasion of the court. Ay, pwede bang back? History. Pwede bang ano? So, ayun. Okay. So, as long as, yun kasi ang problema, nag-motu proprio, dapat nag-proceed siya sa case kung hindi naman ni-raise. Okay, sige. Got it. Okay. Next question. Yep. Si Pauline and Regine had a dispute. Ang tanong dito, tama ba si Attorney Terry? Ano ba sabi ng Attorney Terry? Si Pauline at si Regine nagkaroon ng sigalot sa 500 square meter na naiwan ng parents nila. Si Milka at si James. Okay. So si Milka at James, may anak si Pauline at si Regine. Nung nagbaranggayan sila, usapan ni Pauline at Regine, sige, hatiin natin ng equal yung lote. O tapos, nahati na nga. Nabigay yung title kay Pauline at Regine. Tapos, na-discover ni Regine later on na yung title niya pala, yun nasa Eastern Persian. Kesa yung nandun sa Northern Persian. Yun yung usapan nila sa barangay. So ngayon, nag-file ng petition for annulment of transfer certificate. Pinapakancel niya yung usapan. Pinapakancel niya yung mga titulo kasi hindi siya nasunod. Okay, after trial, the court rendered judgment in favor of Regine. Sabi ng court, oo nga naman, tama si Regine. Dapat sa kanya yung Northern Persian. Yung pala yung usapan eh. Tapos, ngayon, ito naman si Pauline. Kinonsulta si Attorney Terry, a newly minted lawyer. Kumbaga, fresh. Bagong pasa sa bar. Who explained to her that there was a misjoinder of causes of action. When Regine included both annulment of TCT and the barangay partition, as well as judicial partition in the petition. Hence, the trial court erred when it ruled on both causes of action instead of dismissing the petition of Regine. Okay, ang ano dito is, sabi ni Attorney Terry, mali yung court. Misjoinder yan. Hindi dapat pinagsasama yan. Magkaiba ang cause of action. Isa lang cause of action ito. Okay, sige. So, paano natin ito sasagutin? O paano? Sige nga. My answer. No, Attorney Terry is not correct. Okay? Under the rules, misjoinder, there is a misjoinder of causes of action if the causes of action arise from separate transactions. Here, sabi niya, both, yung annulment ng TCT and yung judicial partition. Okay. Here, the said misjoined causes of action actually arose from the same transaction, which is the partition of the 500 square meter parcel of land. Hence, there being no misjoinder of action, Attorney Terry is not correct. Okay. Yes and no. Tama siya na may misjoinder. Okay. Section 5 rule does not allow the joinder upon kasi yung isa ordinary civil action, yung isa special civil action. Kasi yung misjoined, pwede mo siyang either on motion of a party or motu proprio, be severed and proceeded with separately. Here, the actions joined is the annulment of TCT. Ordinary civil action yon. Yung judicial partition, special civil action yon. However, there was no motion of the party to sever the causes of action. Thus, there exists no bar and the simultaneous adjudication both causes of action. Okay. So, it depends kung paano ka sasagot. Paano ba? Yung sagot ko, paano ko scorean to? No, Attorney Terry is not correct. San mali si Attorney Terry? Trial court should have dismissed the petition of the chief. So mali yung sagot ko. Kasi mayroong misjoinder. Kasi dapat, Hindi pwede magsama ang ordinary at saka special civil action. Okay, yun ang natutunan natin sa case to mga kababayan. Hindi pwedeng magkasama ang ordinary at special civil action. Okay? Okay. Okay. Sige. Lap. 6 minutes. Okay, let's go. Hana Corporation is the registered owner of a parcel of tanong. Should RTC grant the motion to dismiss on the ground of forum shopping? Okay. Anong sagot? Forum shopping. Forum shopping. Ba? May answer. Okay. Si Hana Corporation, registered owner ng lupa sa Pasig. St. Aaron School, by mere tolerance, pinabayaan lang ni Hana Corporation na gumamit ng lupa. Tapos, nung sinabi ni Hana Corporation, magcha-charge na siya ng renta kay St. Aaron School simula January 1, 2019. Sabi ni school, ayoko. So ngayon, nagbigay ng demand letter si Hana Corporation. 4.8 million for unpaid rentals from 2019 to 2022. Which is what? 19, 20, 21, 22. 4 years. 4 times 12, 4.8 million. Okay, 100,000 per month. Hindi nagbayad si school. So ngayon, si HC, na may business sa QC, nag-file siya ng complaint for collection of a sum of money against the school in the Regional Trial Court of QC. Ngayon, si school, nag-file siya ng motion to dismiss. Kasi nag-forum shopping siya. Kasi nag-file din ng ejectment case si HC against kay school sa MTC naman ng Pasig. Question. Is there forum shopping? Okay. To answer that, my answer, no. There is no forum shopping. Under the rules, special civil action. Special, ano ba yun? Special civil action ba yun? Unlawful detainer. Is for collection of sum of money is separate and distinct from an ejectment case. Hindi ko nga sure kung yung isa is special at isa ordinary. Sige, kunyari yan lang yung sagot ko. Here, the filing of HC, the separate filing of HC for the collection of sum of money pertaining to the rent in arrears, paid rent, and filing of the ejectment case is a proper way to tackle this case. There There being di ko alam. Okay. Pag may forum shopping, tignan mo, litis pendensya, res judicata. Okay. So kapag ba may judgment sa isang kaso, will it result to a res judicata or litis pendensya on the other? The answer is in the negative. There is no identity of rights asserted and beliefs prayed for between a suit for collection of money and a judgment case, and that any judgment rendered in one of these actions would not amount to res judicata in the other. Tapos na. Dami kong naaral. Thus, no violation of the forum shopping rule was committed. So, tama naman yung no. 3 points siguro to, no? Pag mabait yung examiner, baka mga 4 points. 5 points. Sana mabait sila mag-check. Pero hindi ako pwede mag-rely sa kabaitan nila mag-check. Anyway. Next. Okay. Anjan and Pam were married in 1996. Okay. Copy natin to. However, in November 2003, Pam left for the United States. Hindi naman sila nagkasundo ni Anjan. Noong 2020, nag-file ngayon si Anjan ng petition for declaration of nullity of his marriage with Pam sa RTC Makati, kung saan siya nakatira. Tapos, nag-file ngayon ng issuance of summons by publication kasi si Pam nakatira sa abroad. Yung RTC, dinrite niya yung motion, nag-direct ng summons, ma-serve kay Pam by publication in newspaper of general circulation in the US. However, the copies of the order, summons and comply were not served at her last known address. Meanwhile, no answer was filed by Pam. Thus, the RTC rendered the decision. Okay, question. Proper ba yun? I think the question here is whether the RTC properly obtained jurisdiction over Pam. Answer, no. The order of the RTC is not proper. Under the rules, in order for, under the rules. Under the rules on civil procedure. Pero sige, okay lang yan. Kahit dyan yan. No, the order under the rules. Pahala na si Justice, i-appreciate ko anong rules yung tinutukoy ko. In order for there to be a valid service by summons in foreign territory, there must be the concurrence of two things. One, namely that lagay na lang natin, there must be a service of the copies of the order, summons, and complaint in the last known address of the defendant. Coupled with publication in a newspaper of general circulation in such place. Here there was no service done to the copies of the order, summons, and complaint were not served at Ham's last known address. Hence this resulted to non-conf hence the RTC did not acquire jurisdiction over PAM. Follows as well. No jurisdiction. The ruling of the RTC will not is void. Okay. Okay. Okay, ang haba. There was a service made to the last. Okay. Medyo malapit mo yung sagot. Bigyan mo akong 4 or 5 points, please. Sige, okay lang. Okay lang. I-improve tayo. Babalikan kita. Babangon ako, tudurugin kita. Yung tanong ka. Sige, okay lang. Give the dependent. Ano ba? Ano dito? Here. Okay. Next na tayo. Six minutes yun. Okay. Clarice and Myra offered Gaita. Ang tanong, RTC proper na naman. Lagi na lang natin kine-question ng RTC, mga kababayan. Kaya tayo may bar exam. Tok lang. Kung walang kine-question na, wala na tayong trabaho. Clarice and Myra. So si Clarice at si Myra, inoferan ng trabaho si Gaita sa Indonesia. So binigay ni Clarice kay Gaita yung ticket niya, luggage niya. Nung nandun na siya sa Indonesia, okay. Inapprehend siya ng police kasi may dala daw siyang 2 kilograms ng heroin sa maleta niya. O na-charge siya sa Indonesia ng drug trafficking, tapos na-convict siya to death by firing squad. Meanwhile, in the Philippines, Clarice and Myra, na-arrest sila for qualified trafficking of persons, illegal recruitment, and estafa sa RTC. Gaita was given an indefinite reprieve by the Indonesian government to give her the opportunity to testify in the case against Clarice and Myra. Hence, the people of the Philippines, through the OSG, filed a motion to take the testimony of Gaita upon written interrogatories under Rule 23 of the Rules of Court. The RTC granted the motion of the OSG. Kailan ba proper ang Rule 23? Written interrogatories. Ito yung kaso nung discuss ni Justice. Sagot ko. Yes, the action of the RTC is proper. Was proper. So, ang action ng RTC, ginrant niya yung OSG. Si OSG nag-request ng testimony through written interrogatory. So, ibig sabihin, sinasabi, okay, under the rules, the taking of testimony under written interrogatories under Rule 23. Kala mo talaga alam na alam ko yung rule. Kinopya ko lang eh. Is a mode of discovery available when the ano ba to? Declarant, when the affiant is not available to testify in court, to testify personally in court. Here, Gaita, having been charged by drug trafficking and sentenced, pinahaba ko pa, pwede namang sentence na agad, and sentenced to death by firing squad, is in such circumstance as to render her unable to testify personally in front of the judge, which is here in the Philippines, in Indonesia. Hence, the motion granted by the RTC for the taking of testimony of Gaita through written interrogatories is proper. Okay. Yes. Sentence because is written. However, okay. Although the rule on deposition by written is inscribed under said rule, it may be applied suppletorily in criminal proceedings so long as there is compelling reason. Although the deposition is in writing, the trial court can still perceive the reaction of the department as she answers each question propounded or revoked by the prosecution. Oh, sige. Sabi natin yan. Siguro naman 5 points na yun, no? Diyos ko po. Gusto ko matapos tong bar exam na to. Patapusin niyo na po ako para makapag-insure na ako ng mga tao. Next. Lap. 5 minutes. Oh, provisional remedies. Okay. Kaya na. What action will you file? Where? In what court? Sige, saan to? Si Kaina, registered owner ng bahay sa Tondo, may assessed value ng 900k. Kaina claimed that she allowed Sarah, yung sister-in-law niya, na magstay doon sa house. Years later, Kaina decided to distribute the property to her children. Okay, so she demanded na umalis na si Sarah. However, Sarah ignored the demand. She even filed a case against Kaina, questioning her ownership of the property and contending that she obtained title over the property through fraud, deceit, and falsification. O ngayon, si Kaina nag-send ngayon ng formal demand letter to Sarah to vacate the property. Pero, hindi pa rin umalis si Sarah. So ngayon, magpa-file na ng kaso si Kaina kay Sarah before May 16, 2024. Bago makaalis si Kaina and umalis na siya papuntang United States. Okay, ano ngayon kung ikaw ang abogado ni Kaina, ano yung file mo, saan, at anong court? Okay, sige. If I was the counsel of Kaina, I would advise that she file. Hindi na pala advice. I would file a case. Ano bang case? Ano bang case pa-file ko? Unlawful detainer. Okay, unlawful detainer. Case of unlawful detainer in the municipal. Kasi exclusive jurisdiction ng MTC. Trial courts. O, saan located yung property? Sa Tondo of Manila. Okay, sa Tondo, Manila. Under the rules, unlawful detainer, the NTC has exclusive original jurisdiction over unlawful detainer cases. Unlawful detainer is proper to be filed when there is an unlawful possessor of a property by the owner of his property proper venue for filing this case is in the place where the property resides, is located. Here, the property is located in Tondo, Manila. Kaina is the registered owner of the house and lot, while Sarah is the unlawful possessor of such property. Hence, unlawful detainer filed with the MPC of Manila is proper. Tama ba? Oh, tama ko. Ejectment case. Okay. Hindi ko binanggit yung compassion na yan. Basta merong unlawful possessor. Yun na yun. Ejectment case yan. 5 points to. Alam mo talaga examiner. No? Sana 5 points to kapag sinagot ko sa bar. Let's go po. Relap. Next. Naka 24 na tayo out of 556. Napakalapit na laban naman. Ang lapit. May cream pro pala dito, no? Diktahan ko kaya yung cream pro. Pwede bang i-filter out yun? Sheesh. Pwede bang i-filter out yung cream pro? Punta. Spec Pro. Oh, question. One. Prosper ba yung petition? Karina filed before the Regional Trial Court a petition for change of name. Papalitan niya yung first name, dadagdag niya yung middle name, at itatama yung surname niya ng Lapus to S. Okay. To Z pala. Okay. According to Karina, she has been using the name Karina Garcia Lapus since childhood. Hindi ko alam. Ano ba technicalities nito? Malay ko pa kung Rule 108 or 103 yan. Correction, the surname should be lodged with the courts under Rule 108. O merong Rule 103, may Rule 108. Kapag administrative correction lang, Rule 103. Kapag merong correction ng surname, Rule 108. Kapag may both, Rule 108 na. Okay. Sige. Sana matandaan ko to. William and several other persons were charged with violation of Anti-Hazing Act. They pleaded not guilty to the charge that they unlawfully subjected carding to hazing. Tapos, later, yun naman yung information. Nagdagdag ng 3 to the name of Carding Cruz. Trial ensued without the accused having been rearranged on the amended information. After the accused were convicted by the court, William pleaded contending that his right to be informed of the nature and cause of accusation against him was violated when he was not rearranged after the amendment of the information. There was no mistake in identity. It was mere administrative error. Manghuhula ako dito. No. William is not correct. The correction of Carding Cruz to Carding Cruz III is a matter does not so to a material change in the information and does not change the nature and cause of the accusation against him. Under the rules, there is a need for rearrangement of the accused when the information was substantially, ayun palang term, amended, resulting to change in the nature and cause of the accusation against the accused. Here, the correction of Carding Cruz, hence William's right to William no need for rearrangement of William. Formal amendment. Yun pa lang term. Formal amendment. Medyo tama naman yung concept. Mali lang yung term. So, I'd say 4 points. Justice, please. Ay, sige. Next. Moving on. Here. Ano kaya kung wag na ako mag-ganto, no? Okay lang din naman. Dokumenta lang natin yung sagot ko. Gagawa na lang ako ng bagong card. Rule 110. Cream Pro na to. Cream Pro. Ano bang sagutin yung Cream Pro? Binagsak ko yan eh. Ayoko talaga ng cream. 4 minutes. Sige na nga. Wala naman akong choice. Sabar naman, wala ligtangan. Okay, suggested answer. Ano to? Have jurisdiction to act on the application of for bail. Sheesh, application for bail. Well, kasama naman to sa sige. Angel was charged with murder before the RTC. After trial, the court convicted her of homicide due to the absence of qualifying sentence of treachery. So, nag-file siya ng notice of appeal, tas nag-apply siya ng bail with the RTC before the transmittal of the records to the Court of Appeals. The prosecution opposed the application, contending that the RTC has no jurisdiction to act on the application for bail. The RTC granted the application for bail on the ground that the prosecution failed to prove the 5 bail-negating circumstances. Hindi ko alam yung 5 bail-negating circumstances, pero ang iniisip ko lang dito, ang charge is punishable by reclusion perpetua. So, it's a non-bailable offense if the evidence of guilt is strong. Before the CA. Tama ba? Hindi ko alam kung tama yun. Anong gagawin ko ngayon? Tanong, may jurisdiction ba yung RTC? Sa RTC pala yung usapan ng matter of a right, no? Pag sa RTC, the evidence of guilt is strong. Convicted na nga eh. So strong. Non-bailable offense. Okay, sige. Isipin natin non-bailable yan. Kailangan ko talaga tong cream. Pero not for long. My answer no. Have jurisdiction. Under the rules on criminal procedure, bail is not available for cases punishable by reclusion, perpetua, or death when the evidence of guilt is strong. Here, there was already a conviction by the RTC indicating strong evidence, proof beyond reasonable doubt as to the guilt of the accused. Hence, this is a non-bailable case and the RTC is precluded from granting the application for bail. Sana tama. Change. It's non-bailable. Available ba ang homicide? Ano daw? Convicting the accused change the application for bail. Mapa-file mo lang siya sa appellate court. So sa CA. Well, at least no. Pero mali yung rationale ko. Pero no. Bigyan mo ako ng 3 points, please. Scorean ko kaya yung sarili ko. Sabi ko na kahinaan ko tong claim ko. Okay lang. Not for long. Not for long. Ilan ba ang goal kung matapos na tanong dito? Limited. Tapusin mo yung 500 na yan bago matapos yung coverage ng claim card. Teka, bago ako mag-suggested answer. Teka lang, kung babasahin. On is the position of Erica tenable. A warrant of arrest was issued against Erica. Noong 11 p.m., October 30, 2021, inaresto siya sa house pursuant to the arrest warrant. Before na-arraign, si kinwash niya information kasi yung serve at nighttime and beyond 10 days from its issuance. Hindi ko naman kasi alam kung tama ba yan. Oo na, 25. Give me 25. Tayo na napakaraming puno. Puno. Walang anong sagot. Pwede magbigay ng arrest anytime. Hindi rin pwedeng gamitin na ground to quash information ang improper service of warrant. Ano ba ang grounds for motion to quash? Uh, 10 days from its receipt. Okay. So in short, mali lang si Erica. Okay, sige. Sige. Ay, mali. Sige, okay. Next. Cream Pro na naman. Gusto po. Hirap naman. Information for corruption of public officials was filed against Bell. Assistant Prosecutor Chi, the investigating prosecutor, certified that the same was filed with the prior authority of Chil, the city prosecutor. After the presentation of evidence, trial court multiplier dismissed the case on the ground that Chi does not have the authority to prosecute the case because the information does not bear the signature of Chil or any other indication that she approved the same. Hindi naman siya jurisdictional defect. May case nito eh. Hindi siya jurisdictional defect. No, the trial court is not correct. Under the rules, the failure of as decided by the Supreme Court. As decided by the Supreme Court, the failure of the city prosecutor to sign the information does not give rise to a jurisdictional defect. However, in fact, this may be validly raised as a ground to quash the information. Upon arraignment, the defect of not validly raised before arraignment, the same is if not validly raised before arraignment. Ano sasabihin ko? Aside from the failure of the city process does not give rise to jurisdiction. However, this may be validly raised as a ground to quash the information. If not validly raised before arraignment, the raise is deemed waived. Okay. Here, the dismissal by the trial court by virtue of the missing signature of the city prosecutor motu proprio dismissal by virtue during trial here is improper as the defect in the signature was not timely raised. Here, the motu proprio dismissal by trial court by virtue of the missing signature due to the missing signature during trial is improper as the defect in the signature was not timely raised. Hence, waived. Hence, trial court should not have dismissed and heeded the trial condition. Ang haba naman ng sagot ko. But ito ang ikli lang. Hindi. Open close natin. Yeah. Zoom out, zoom in. Yan. Diba? Na-wave. Tumatama rin naman tayo kahit paano mga kababayan. Kahit paano mga kababayan, tayo ay tumatama. Here. So, evidence. Thank you, evidence. Ayoko na ng crime pro. Papagod ako pag crime pro yung tanong. Ano ba yun? Oh, lagi na lang kina-question ng trial court. Raisa filed a case for support against Ton on behalf of their 9-year-old daughter, Rox. During trial, Rox was presented as a witness. The counsel of Ton invoked the rule on the incompetence of Rox to testify against her father given her tender age. Given her tender age. The rules on child testimony, ano yun? Ano ba to? May case ba to? Pwede ba nga? Sige, may answer. Yes, the trial court is correct. Under the Children's Protection Program, children under the rules. Under the rules. A child may validly testify in court. Here, counsel of Ton invoke incompetence only by virtue of tender age. It is of no moment that a child is of tender age. This is not a circumstance where the court would grant testify. Hence, trial court is correct in allowing Rox to testify. Okay. Oh, lahat pwedeng mag-testify. Rules of court. Okay. Ang haba. Ang professional. Ang professional sagot. Yung akin ang likli lang. Pero siguro naman tama to kahit mga 3-4 points. Tama naman. Yung concept medyo hindi ko alam paano i-appreciate yan ng court. Ng justice. Ng examiner. Sana appreciative sila. Pinagdasal. Sana po appreciative yung mga examiner namin. Yun pong chairman namin. Diyos ko. Nagdasal. Okay. Next. 10 minutes. Di ba ako nag-next? 10 minutes ako nasagot nun. Anyway. Okay pa din yun. Ba talaga kapag naka-livestream ako? Feeling ko, alam ko meron ako accountability body na parang random na invisible dyan. Na tinititigan ako, Carl, mag-aaral ka. Pero at the same time, wala akong kadaldalan. So, in short, nakapag-focus ako. Pero na akong accountability body na hindi nakikipagdaldalan sa akin. Good accountability body. Yeah. Let's go. In a criminal case for murder filed against Erica, the prosecution presented Chell as an eyewitness to killing of Lai. Chell testified that while 3 of them were on board the boat, Erica shot Lai with a .45 caliber pistol and threw both the gun and the body of Lai to sea. Efforts to retrieve the gun and body of Lai were successful. Evidence was likewise introduced to prove that Lai was thrown in a shark in the pested area. Erica consulted her nephew, Ted, a recent law school graduate, who is reviewing for the bar, same as me. Confident of an acquittal, Ted recommended that Erica file a demurrer to evidence. Ano naman yan? There is no corpus delicti due to the failure to recover the gun in the body of Lai. The prosecution failed to prove that Erica fired the gun due to the lack of a paraffin test. Okay, ang tanong kasi dito, di ba? Si Chell is an eyewitness for the killing of Lai. Si Chell, sabi niya magkakasama sila sa bangka, binaril niya si Lai, tapos tinapon niya sa sea yung baril at saka si Lai. Oh, so wala nakuhang Lai, walang body of evidence. Pero merong introduction of evidence, si Lai natapon siya sa shark infested area. Okay, so there's nothing na pangahawakan. Merong evidence. So circumstantial na to ngayon kasi na-prove ngayon na natapon sila sa shark infested area. So pwede mong i-prove was thrown na hindi nahulog. Okay, so possibly yes, walang body of crime, pero hindi siya demurrer kasi merong evidence na nalaglag siya sa shark infested area. Pero mahirap talaga i-prove yung firing ng gun. Is Ted correct? Ang hirap naman. Hindi, madali lang to. Mindset. My answer. Ted is not correct. Definitely, may evidence eh. So, hindi ka magde-demurrer. Under the rules, demurrer to evidence is only proper when is proper when the under the rules, the demurrer to evidence is proper. Bakit naman kasi nagko-consult ka kay Ted? Tuloy ako namang problema ngayon. Tama ba si Ted o hindi? Ted is not correct. Under the rules, the demurrer to evidence is proper when there is proof beyond reasonable doubt cannot be established with all the evidence submissions filed by the prosecution. Here. Evidence was introduced whereby to prove that Lai was thrown in a shark infested area. When corroborated with Chell testimony, so may evidence na tinapon siya sa dagat. Against Erica. Hence, the mirror evidence will not result to an acquittal. Sige nga, tignan natin. Itong hula ko is... Siyempre mali si Ted, definitely. Law student ka eh. O di naman, law student. Presentation of the words not indispensable. Okay. A certain result has been established. Okay. Fired again. Ang layo ng sagot ko. Tama yung no. Sana 5 points. So, ito kasi dapat yung sinagot ko. Walang corpus delicti. Ang sagot, hindi indispensable ang murder weapon. Okay? Hindi siya element ng murder. Okay. And then the prosecution failed to prove that Erica fired the gun. Further, paraffin testing is conclusive only as to the presence of nitrate particles in a person, but not as to its source. So essentially, kung mag-paraffin test ka at bumarel at meron kang nitrate particles, possibly may bumarel din sa katabi mo. So kung halimbawa, nag-positive nga si Erica, possible din mag-positive si Chel kung magkatabi sila ng bumarel. So it does not prove. It indicates a possibility but not infallibility that the person has fired the gun. Let's go. Next. Evidence. Ano ba to? Puro ano? Crime pro. Ako ano? Evidence pero crime pro yung tanong. Evidence as to criminal case. While relaxing one Sunday afternoon, Kesh suddenly felt sick. While she was on the verge of losing consciousness, Kesh called for Robert. Her personal nurse said, "Call Dr. Nancy forthwith." Robert asked Kesh about what happened, and Kesh further relayed, "I'm probably going to meet my creator. I ate the instant noodles prepared by my husband last night, and I think he put poison in it." The following day, Kesh passed away. The certificate of death issued by the medical legal officer who conducted the autopsy reflected the cause of her death as aneurysm or rupture of a blood vessel. Oh, aneurysm pala eh. Later, the husband of Kesh was prosecuted for murder. During trial and apart from the medico-legal certificate, the prosecution also offered in evidence the testimony of Robert to prove the utterance of Kesh. Is the statement of Kesh admissible as a dying declaration? Explain. She was on the verge of losing consciousness. Sa personal nurse, ano nangyari? Siguro, mamimit ko na yung creator ko kasi nilagyan ng laso ng asawa ko yung pagkain ko. I'm probably. Hindi siya dying declaration, nanguhula lang siya eh. When you feel suddenly sick, and mawawalan ka lang ng consciousness, doesn't mean you're automatically dying. As aneurysm. So, aneurysm, rupture of blood vessel. Hindi naman talaga poison. O, bakit na-prosecute yung murder yung asawa niya? No. No. The statement of cash is not admissible as a dying declaration. Under the rules, a dying declaration must be on the actual perceived moment of due to extra circumstance that in the natural course of things would result in his death in the next few moments. Gumawa na ako ng sarili kong definition. Meron po akong sariling rules of court. Here, the mere statement of Kesh saying that she think he put poison in it is not uttered on an extraordinary circumstance. It was a relaxing Sunday afternoon. And she was not suddenly got sick. This is not what is contemplated in the sense of dying declaration. Hence, the cache of the statement cache is inadmissible. It's dying declaration. Yes! Zero agad yung points ko. 4 conditions. The declaration must concern the cause and surrounding circumstances of the declarant's death. That at the time the declaration was made, the declarant is conscious of his impending death. That the declarant was competent as a witness. And the dying declaration is offered in a case in which the subject of inquiry involves the declarant's death. Further, the declaration must be made in extremity when the party is at the point of death and when every motive of falsehood is silenced and the mind is induced by the most powerful considerations to speak the truth. The law deems this as a situation so solemn and awful as creating an obligation equal to that which is imposed by an oath administered in court. Here, all the requisites are present, thus the statement of cash is admissible as dying declaration. Malay ko naman dyan sa 4 na requisites na yan. Sabi ko mag-aaral ka pa, Carl. Ay, salamat sa kasong to. Salamat dito sa Remedial Pro. Ang daling mag-aral. Kasi mag-ahagil pa ako ng Q&A. Ang dali-dali. Nakaganto na siya. Ay, napindot. Okay, okay lang. Vanji filed an action for compulsory recognition with prayer for support against Che, her putative father. During trial, she presented and identified the following documents on the witness stand. The birth certificate of Vanji. Ang question ba dito? Rule on the admissibility and sufficiency of the documents as evidence of acts or declarations about pedigree. Okay. So, ang present birth certificate ni Vanji na tatay Reflecting J as the father of Banji for information supplied by the mother of Banji. So, hindi pinirmahan ni J. And letters from the siblings of J addressed to private schools where Banji was enrolled, which attested that J is the father of Banji and that he regularly supports her education. Letters from the siblings of J addressed to private schools where Banji was enrolled. So, yung mga kapatid ni J, sinabi sa mga schools na si J talaga ang tatay niya si Banji. And susuportahan niya yung education. Mali ko naman. Hindi ko alam sagot. Balikan ko na lang. Inefficient kung sagutin ko to ngayon. Ang mahula ako. The birth certificate is admissible while the letters from the siblings are not. Bakit? An act or declaration about pedigree is permissible when the actor or declarant is dead or unable to testify. The act or declaration is made by a person related to the subject by birth or marriage. The relationship, okay. So, meron ganun. Okay. Admissibility, admissible yung public document, yung birth certificate. Pero as to sufficiency, hindi siya sufficient kasi hindi naman pinirmahan ni Jay yung birth certificate. Okay. Sige. Sorry. Ito na-copy yung question. Okay. Grabe. 556. Paano ba bibilis yung review ko nito? 3 years na ako nag-aaral. For those 36 questions. So, 3 hours. Ilan yun? 6, 12, 18. Let's say 180 minutes divided by 36. Divided by ano na lang. Kasi 36. 5. So I can answer 5 questions. 5 minutes per question ang ano ko. Tama ba? Oo, 5 minutes per question. Multiplied mo by 556. 2780 minutes divided by 60. 46 hours. 46 hours. Pag tinrabaho ko to ng, let's say ano lang, 4 hours a day divided by 4 hours a day. 11 days bago ko matapos lahat to in one padaan. Ano ba yung schedule ko? College star. So, let's go. Download ko ba yung latest? Ito ba yung latest? So, ibig sabihin, ngayon is 16. It's Friday, May 16, 3:02 a.m. Okay. Merong special penal loss ngayon. Tapos bukas. Codal rehash lang pala to. Meron pala lang. So, 11 days. Ang 11 days is 16 plus 7, 23 plus 4, 1, 2, 3, 4, 27. By 27, tapos ko na lahat ng Q&A na to. Oo nga, 16 plus 11. Baka nagpakahirap pa. Pwede. Mas makapag-umpisa na ako ng civil law. Kaso, ilang tanong yung sa ano? Sa crime. Sige na ako di matapos yun. Remedial to. Ilan sa criminal? 500. So mga ilan din yun? 100. Ano? 500 questions multiplied by 5 minutes. Divided by 60. Divided by 4 hours. So, halos 11 din. 10.5. So, ganun din yung timeline. So, sige nga, plot natin sa calendar ko yung ano. Diba? Teka. Natin sa calendar. Kalendaryo. So, special penal laws. Sige nga, 4 hours. Saan ako magde-dedicate ng 4 hours a day? Let's say 12 a.m. to 4 p.m. to 4 a.m. 12 to 4. Kung 12 to 4 for 11 days. Tsaka 10 days. So, mula ngayon, 16 ngayon. Dagdagan natin na dito. Adjust ko na lang. 4 hours hanggang 4 a.m. Ano to? Answer for Q and A. Ano pa to? Rem, bar, Q, and A. Tapos, it repeats. Ano ba? Daily? Hanggang Sabado? Oo, walang patawad. Wala tayong pahipahinga. Walang karapatang magpahinga. Mga tao, uhaw sa pangarap. Uhaw sa pangarap. Meron naman. Papahinga naman ako after nun. Sige, daily. Daily, no? Kailan? Kaya nga. Gusto natin. Repeat every one day. Tapos, it will end kailan? Sa 27. May 27. Okay? Save. Bar review. Yan. Tapos, yan, locking na ako. Bar Q&A na yan. Tapos, tatapusin ko naman yung bar Q&A ng cream in 10 days. After that, hindi ko alam paano ko sisingit na yung cream bar. Paano ba? Cream. Picture ng calendar ko. Sige, tapos maglalagay dito tayong cream bar. Q&A. 10 days. Allocate tayo ng 10 days. 10 days. Daily. Matatapos siya. Kung 27 to, 28 plus 10. 28 plus 10. May 29, 30, 31. June 7. Dapat Tapos na ako ng June 7 dito. Dapat mapabilis ko yung pagsasagot ko nito. Basahin ko na lang siguro, no? Basahin ko na lang muna. Saka na ako kaya ko namang mag-produce ng sagot on the spot. Siguro practice na lang ako padulo na pag na-cover ko lahat. Pag alam ko na. Mabilis naman magawa ng sagot. Mabilis naman mag-focus. Mabilis ng magic. Okay. The bar review. Tapos 12 to 4. Okay, cream. Tapos, by that time, ano na yung kasunod? June 8? Ano ba sabi sa June? Labor law na yung June 8. So, dapat matapos ko din yung Q&A na civil law. Ilang tanong yung civil law? Sige nga. Ilang tanong ang civil law? 558. Mga ano yun? Palagay lang 10 days. O, sige, 10 days ang standard natin. 10 days. Bigyan ko ng 10 days ulit. 10 days? Wait naman. Bar Q&A. Wala na mangyari sa buhay ko nito. Singit-singit na lang yung panonood ko ng mga video nito ng Legal Edge. Ito naman ang kailangan kong gawin, mag-bar Q&A. This is what productivity means. Reading and listening and watching does not produce the results I need. I have to be practicing answering questions. That is what we need. So from June 8 to June 18. Sige. Okay. So June 18. June 18. Nakahabol na ba ako nun? May bar exam trial ba dito? 21? Cream tapos rem? 21? Ano ba ngayon? 16? 5 days? Paspasan ko kaya yung buong cream at rem. Basahin ko lang lahat. Sige. Habulin ko tong bar exam na to. Though hindi ko alam po yung bar exam trial. Ibibigay nila ngayon yung copy. Kasi hindi ako nag-enroll sa bar exam trial. Paano ibigay nila yung questions man lang? Kasi discuss nila yung sagot. General rule naman yung MacBar, di ba? Sige. Ano kaya? Makapag-enroll pa ba ako sa bar exam trial? Student. Ano ko itong with checking? Wala na. Wala nang chance. Mahal kasi. Wala nang package. Ito, package 4. Ito ang kinuha ko yung package 4. Hindi ko makita. Hindi ko makita yung packages. Ang password ko dito. Yun. Pwede bang i-upgrade yung akin from package 4? Ano ba yung kulang? Package 8. Wag na nga mag-macbar. Okay lang. Okay lang na wag mag-macbar. Sana may macbar pero okay lang. Dami naman natin sagutan. Medyo nagiging confident naman tayo dito. So, ano ba next? Ang dami. Cream simula 28 hanggang 7. Tapos 8 hanggang 18. Ano 18 lang? July. Ba't naging July? June lang. Okay. Tapos from June 19. Sige, tapos muna tayo mag-aaral. Planning muna tayo ulit. Planning. Let's stop the focus. Okay, thank you for watching the stream, guys. Paplano muna ako.